I think we have a panel this afternoon now that is on a subject that I really haven't heard at a lot of these events. We don't often talk about the alternative to ISDS. What if this all went away? What if the governments chose to go down a different path? And we really do have an interesting group of panelists here. We're going to do the same format as this morning. Each of these speakers has about 15 minutes. I'm going to ask them to keep to that. Maybe even if you can do it in shorter, I'm sure the crowd would applaud you. We will then be joined by a couple of additional panelists, and we'll have another lively Q&A. You set the bar high in this morning session. Your responsibility as a crowd is to come up with equally provocative questions in this afternoon session. So why don't we start off here really with XavierCarim, who is South Africa's ambassador and permanent representative to the WTO, the World Trade Organization. But he also, and we were talking about this beforehand, was the person in charge in the trade ministry, really, of thinking about investment policy at a really interesting moment in history. South Africa, for those of you who don't know, is a country that 2 years ago, was it? That 2 years ago decided that it had had enough of these bilateral investment treaties to a certain extent and decided to terminate them and to explore alternatives. So XavierCarim is here to walk us through exactly what happened then and walk us through a very interesting example.
Well, thanks very much. I'm going to take advantage of my new position as ambassador and sit and talk instead of stand up there and deliver a speech. But first of all, let me thank the organizers for inviting me here today, and particularly for requesting that I share with the group the South African experience on this. So I can actually be quite brief. I'm not speaking about the TTIP. A lot of the discussions that you have had this morning are very interesting to me to listen, and a lot of it reminds me of some of the discussions that we had in South Africa some years back. I think our discussions were probably not as complex that you're having to engage with here, but I think some of the same sets of questions that you're grappling with, we had to grapple with some time back. Let me just say, I think that I'll give an outline of our experience of what the evolution of our thinking on investment policy and investment treaty policy in particular, and you can decide if there are any lessons that can be taken. For South Africa, our experience with IIAs, with bilateral investment treaties, starts in about 1993. We signed our first bilateral investment treaty with the UK. This is in the period of just before the transition from apartheid to a post-apartheid dispensation. That treaty in 1993 was followed in very rapid succession of signing a number of other treaties very quickly, mainly with European members. It was generally the motivation for it was given to us. I don't think we did too much of an analysis of it. It was seen as part of what you do when you rejoin the international community, and South Africa coming out from the isolation of the apartheid years. This seemed like you sign a double taxation agreement, you sign a bilateral investment treaty. It sends a signal to foreign investors that your economy is open, you're open to FDI. And it's presented as largely unproblematic. And I think as James's graph showed, it was at the high point of signing investment treaties in the mid-90s. So we followed the trend. But there's been a learning. Since then, we have participated. I think we watched from afar the discussions on the multilateral agreement on investment in the OECD. We participated in the discussions on trade and investment in the WTO when it was it was an attempt to bring it into the, as part of the Singapore issues, into the Doha round. And then you begin to see that these are not necessarily unproblematic, that there are risks and there are different perspectives on it. Probably more importantly, the increase in the spike in international arbitration after 2001, after the financial crisis in 2001, and two cases that were brought against South Africa in, I can never quite remember the dates, but it's about 2003, 2004, 2005. Two cases that we were involved in, kind of focus your mind. So we started to have to engage with those, and in 2007 we initiated a review of all our bilateral investment treaties. We have something, if you go onto the UNCTAD website, I have to tell James this, if you go on the UNCTAD website, it says that we have about 40 bilateral investment treaties. In fact, there's only about 20 that have actually entered into force. So we're talking about 20 bilateral investment treaties that were in force. We undertook a review of that. It was a 3-year review, intensive set of consultations, business, labor, government departments, international experts, different non-governmental organizations over this period. And I think the outcome is more or less highlights the problems that have been discussed already. I think the one point that I hadn't heard of in the discussion this morning, we've talked about the risks, we've talked about problems in the provisions, how to tighten up the provisions, we've talked about the shortcomings in the arbitration system itself, but the one question that hasn't come out sufficiently, at least for me, at least the parts that I was understanding, is what are the benefits? I mean, we keep talking about these are the risks, and we're going to try to find ways to reduce the risks associated with ISDS, but what are the benefits? And what had been proposed to South Africa when we signed them, that is, if you sign these agreements, you'll see increases in FDI flows. What we've seen is that there is no link. I mean, South Africa's case is quite clear. We get large flows of FDI from the US, from Japan. We don't have any bilateral investment treaties with either one of them. We have bilateral investment treaties with a range of other countries that we don't get much FDI. So there's no link between FDI flows. At least it's not obvious that there's any link between FDI flows and is that 15 minutes up already? No? Oh, okay. All right. So aside from the risks associated with the poorly drafted treaties, the problems in the ISDS, the fact that there's this imbalance in the agreements, in the overall structure of the agreements that tend to favor investors over government policy. I'm talking particularly about the treaties that we had signed in the mid-90s. The fact that these have subsequently raised constitutional questions of whether these are actually constitutional in the South African case. All of those, in addition to the question that the review suggested that there was no necessary link between FDI, that was the outcome of the review. That was presented to our cabinet in 2010, and in July 2010, the cabinet took a decision based on all of these factors and essentially said, one, South Africa should move to terminate the bilateral investment treaties. We should consider renegotiating investment treaties if it can be demonstrated that there's an economic benefit to South Africa. 3, if we're going to negotiate it, it needs to be on the basis of a new model that we have to develop. And we should strengthen or clarify some of the investor protection provisions that you find in bilateral investment treaties into South African law. So, for instance, we don't have any specific provision in our law that talks about national treatment. With the new act, we will take that provision and we'll clarify what it means in light of our constitutional framework and the existing legal framework. All of that work was undertaken. All of this work was, the other part of the decision was that all of this work should be undertaken under the oversight of an interministerial committee So in the past it's been taken out. In the past it was really almost a bureaucratic process of negotiating these. Now it has very clear political oversight, the entire process, termination, development of the new act. So what's happened since then? That was a decision in July 2010. Since then, we've moved to terminate the bilateral investment treaties. The first batch was with the European Union, but we have a few in Latin America, we have a few in Africa, and we have a few in Asia, and the process of termination is continuing. We've developed a model bit in a regional context in SADC, the Southern African Development Community, 15 countries. We have a model bit which, if we were going to negotiate an investment treaty in future, that would be the basis on which we would move forward. Importantly, that offers the option of state-to-state dispute. It doesn't allow, it does have ISDS, but there's an option there that one would have to consider. And the third leg of our work has been the development of a new investment act. And I think this raises the point, I think Celeste had raised this earlier, about the importance of strengthening your national legislative and judicial framework to protect investment. And so that work is fairly well advanced. We should be submitting this act to Parliament in the course of next year. It should become an act of Parliament, and effectively what it will do is, as I said, doesn't add any new obligations on foreign investors. It ensures that South Africa remains open to foreign investment, but it also underlines and strengthens the references to the right to regulate in particular areas. And importantly, it says that if any investor has any problems, expropriation or any other type of problem that they may face, they have access to South African courts. So there's no international arbitration. Now, I'd say that there is a broad consensus in South Africa on the process and on the objectives that we've embarked on, and this is a product of the very extensive consultations that we had. So across the board, there's an understanding of why we're doing what we're doing. And maybe just as a final point, I still have 4 minutes, so you can applaud after that, that our flows of FDI have continued to increase. The UNCTAD World Investment report of last year talks about a rebound in FDI in South Africa and foreign investment flows into South Africa. I mean, we always think that we're not getting enough, but last year was a particularly good year. Some other analysis is showing that there were announcements to either for new investment or expand existing FDI at the rate of 2 a week throughout 2014. So my experience in government over the 20 years, I've never heard an investor say that they're investing in South Africa because there's a bilateral investment treaty. I've never heard an investor say that they're not investing in South Africa because there's no bilateral investment treaty. So they're not decisive. You have a legal framework. If the companies see that there are profits to be made, they'll come in. If they have recourse to the courts, it's generally good enough. Thanks very much.
Thank you. Leave that on, and we'll hand that across. With 3 minutes left, so you definitely deserve it. You set the bar very high there. Our next speaker, Sanya Reid-Smith, who we heard from the floor earlier, is from the chorus. The microphone. My apologies. I'm used to speaking loudly. Our next speaker, Sanya Reid-Smith, is legal advisor and senior researcher with the Third World Network. Sanya, you've got 15 minutes, and he had 3 whole minutes left at the end there. Can you beat that?
I will do my best. Thank you, everybody, for making time to come, and to the organisers for including me. I'll just pick up on some of the things that have been mentioned. And so one of them is the impact on subnational governments. So of course many of you know the metal-clad case under NAFTA, where a subnational government refused to give a permit for a toxic waste dump because it would pollute the water supply. The Mexican government was sued under NAFTA, lost, had to pay $16 million US, and they tried to get it back from the subnational government that had refused the permit. Under Mexican law, that was not allowed. But I don't know, in each EU member state, can the EU government or the national governments get that money back from the city government, from the provincial government? What about if it's a different political party at the subnational level who has different policies? And this has actually been a problem in Canada, where recently an Ontario province stopped a quarry. There was huge protests. They were sued, and the province paid 2/3 of the cost that the company had spent on setting up the quarry. So you can see that subnational governments, this is in the US, are worried about this. This is the National Conference of State Legislatures. This is all the parliaments of all 50 US states, Republican and Democrats, all the things they're worried about in treaties such as TTIP. They don't want their laws to be covered. They don't want negative list liberalisation, they want positive list. They don't want anything that stops renationalisation of failed privatisations. They don't want a non-discriminatory law to violate, say, TTIP. They will not support anything that has ISDS. And I think this is a repeated resolution every couple of years. They don't want the ISDS decisions to bind the subnational governments. They don't want their national government to be able to get the money back from them if it was their law that caused the decision against them. And they don't even want to have to pay the costs of defending a case, because this was a problem, I think, for California, that when one of their laws was challenged, the US government defended under NAFTA, and they said, California, you pay the lawyers, it was your law. So they had to pay, was it $6 million or something, and they just didn't have any budget for it, even California. On the next slide, we can see there's a couple of other issues to touch on. Those of you who support the Tobin tax, of course, the investment chapter of TTIP will have free movement of capital. That's the US model. I have never seen them agree to an exception for a Tobin tax. You heard this morning that they're unlikely to change their model. I think you can give up on that. Sovereign debt restructuring, there's an UNCTAD paper that shows that there are 5 investment chapter provisions that are problematic for sovereign debt restructuring. There's been a lot of cases here in Europe, of course, when Greece did sovereign debt restructuring as required by the Troika. They have been sued under an investment treaty for violating expropriation and fair and equitable treatment. Even if you get an exception for this, will you get it for bank nationalisation, like the Troika required of Cyprus in this financial crisis, and for which Cyprus is now being sued for more than €1 billion under an investment treaty? Separation of powers. We heard about the importance of the rule of law before lunch. Some people say this includes an independent judiciary. So you separate the courts from the executive branch of government and the legislature. But we already know that the ISDS tribunals have more than once ordered the executive branch of government to violate the constitutional separation of powers and interfere in the domestic court decisions. This has happened more than once. And I'm sorry to say that in CETA, there is no safeguard against this. This can happen to you under CETA. Too bad that it's against any constitution in an EU member state. In addition, some of the issues that have been raised are counterclaims. So this is what happens if the investor breaks the law. For example, they act corruptly. Some people say the rule of law is no corruption. Well, under the US model, there is nothing to prevent a corrupt investor suing and winning. CETA, you can't use ISDS if you make the investment corruptly, as happened in India with the 2G phone licenses. But if the American investor comes in legally and then acts corruptly, they can still sue you under CETA. And they can still win, and they can still get damages. That's no problem. So we know that there are many cases where the foreign investors break the law and where the governments have no defence that you broke the law, therefore you can't sue, no clean hands, or you get a reduction in damages. Because to get a counterclaim, you need about 6 provisions. None of these are in the leaked TPP investment chapter or the US Model Bilateral Investment Treaty, and there has never been a successful counterclaim by a government under an ISDS dispute. So, if a US investor breaks the law in Europe and you punish them, say they break the environmental law, you fine them, you cancel their permit, as you're allowed to under your domestic law, that company can still sue you and still win and still get damages. It's called pay the lawbreaker, and this has been required in many cases. So this allows investors to act with impunity. So your domestic companies must comply with your environmental laws, your health and safety laws, but the foreign investors, if you punish them, they can sue you back. That's the ultimate appeal tribunal. So it doesn't seem like equality under the law, which some people say is part of rule of law. The other thing that you might be interested in is compound interest. I don't know if that's allowed in European domestic systems. For example, in the Trans-Pacific Partnership Agreement, some developed countries don't allow the government to have compound interest awarded against it in domestic courts and domestic law. Compound interest, of course, is interest on the interest. But in CETA, in the US model, in the League TPP investment chapter, they have all agreed to interest which can include compound interest, compounded every month at commercial interest rates, not government borrowing rates, from the date the government took the measure 5 years ago. So you won't be surprised to hear that the interest alone has been $589 million US. It's been bigger than the awards in some cases. So this is what else you have to look forward to that the US is unlikely to change. Then we heard about the costs. So of course this year the big news is the $50 billion US award against Russia, which they have 180 days to pay, because of course there is no maximum size to the awards under these treaties, and you can't expect it in TTIP either. But what about the legal fees? How much you pay the lawyers and the arbitrators, even if you win a case? So of course this can be $8 million a case on average, or more than $30 million US in some cases. And one study found that even when governments win, even on jurisdiction, 80% of the time they have to pay their own costs. But if the investors win, they only have to pay their own costs 40% of the time. Sorry, if the investors lose. It's the other way around. So anyway, the governments pay their own costs twice as often as the investors in this neutral international tribunal. So then of course the question is, what is the impact on foreign direct investment? Because we heard from Ambassador Karim, why do we have these treaties? Does it bring FDI? And he gave the South African example. And of course there have also been surveys by US and European academics who actually go and ask the multinational companies. They ask the political risk rating agencies. They ask the political risk insurance agencies. Do you check if there is a bilateral investment treaty before you invest, before you give a risk rating, before you give political risk insurance? And basically the answer is no. A literature review by a European academic of all the other studies and surveys found the same thing. The vast majority of multinationals do not take this into account when deciding where to invest. If you look at the econometric evidence, it's mixed. Some say yes it helps, some say no it doesn't, depends on the methodology. The most recent report from UNCTAD this year found that it had no effect whether you have a bilateral investment treaty on foreign direct investment flows from north to south. Then lastly, if you didn't have ISDS, sorry, the topic of this panel, one of the options that you could have is use domestic courts. Now most people say US and European courts are fine, there's no problem with them. So, no ISDS means you still get all your rights under domestic law and domestic courts. You could still use political risk insurance, you could still use insurance contracts, as Associate Professor Van Harten will say. But what happens if you do have ISDS? Associate Professor Van Harten's research shows that 44% of ISDS cases involve domestic court decisions in some way. So it's a real problem that your domestic courts may no longer be the final decider, or in this case the European Court of Justice, of your laws. So you can see that the judges in many countries are worried about this. So this is a statement by all state level courts in the US. So national, state. All the state courts have urged the US Trade Representative not to have agreements like TTIP that mean that their judgments are no longer final. And you can see that the Australian High Court, that's the highest court in Australia, the Chief Justice there gave a 15-page speech to the other Australian judges in which he gave all his concerns about ISDS, and he suggested, because you know judges are very polite, that you should not be able to challenge a domestic court decision under bilateral investment treaties. And of course the Singapore Attorney General gave a 30-page speech about all the problems with ISDS, not just about the impact on domestic court decisions. So lastly, I just wanted to mention, because this is a TTIP topic, that even if you think you get better wording in the signed text of TTIP investment chapter that fixes some of these problems, don't forget about the certification process. So, of course, the text will have to pass the US Congress to come into force. With fast track, that means it takes a majority of the US Congress to make any changes to the text. They can still force open the text, as Korea found, on certain issues, even with fast track. Of course, today there is no fast track authority in the US, so a small group of senators, a committee chair, can force a change to the investment chapter if they want something else. Even after that, there is one more stage called certification, which I understand from the US experts will be applied to TTIP. You have this to look forward to. And what it involves, and you can see more information at this website on the memo, is that the US government writes the implementing laws for you for TTIP. They give them to the European Parliament and they say pass them with no changes. And we actually have at this website, under Freedom of Information, the emails from the US government to other governments they have signed free trade agreements with, saying here is the law that you must pass with no changes. The other government writes back and says, yes sir, we have passed it with no changes. So for those of you who are in the European Parliament, this may be of some concern to you. Because of course, as you know, when you negotiate sort of ambiguities in the language so that you can go away and interpret what you think fair and equitable treatment means. But, as the Australian government found in their US free trade agreement, that exact ambiguity is written out in the implementing law that the US government wrote for them and said, here, this is what you have to pass. The Australian government passed it, the Parliament passed it, as written by the US. And straight after they found that as written by the US, it doesn't work. The exception they thought they got was too narrow. And the Australian government's law reform commissions ever after have said, we need to fix this, it's not working. But that's what they passed, because that's what the US government wrote under the certification process. In this process, they also make extra demands that are not in the free trade agreement. So some countries had to give an extra monopoly on medicines for another 3 years. And it's not just the US Trade Representative's office that makes the demands, it's not just the US Congress, but even one US company. We know that Chevron, for example, asked for an unrelated law to be repealed in the Dominican Republic. Nothing to do with the free trade agreement with the US. Completely legal. Under the free trade agreement, they just didn't like it. So they said, we want that law repealed. As part of the certification process, they got USTR to agree. Dominican Republic had to repeal the law. A couple of days later, the free trade agreement comes into force. So I just wanted to add that when you're thinking about getting some language that might help in TTIP. Thank you.
Thank you. Thank you, Sanya. It's an interesting thought crossed my mind, which is I wonder what the European Commission would make of that idea of certification. Presumably they get to write the US law that goes in exchange.
No.
Well, they might insist on it.
They don't have to change much law. They're exporting their own law usually. So nothing has to go through the Congress, so there's nothing to certify.
Well, that's we'll see what the Commission lawyers say. But well, thank you for that, thought-provoking, and also with 2 minutes left, which is impressive as well. Which leads us to our last presentation before we get to the very lively Q&A that you guys are all going to provide. Gus van Harten from Osgoode Hall Law School. Now, I'm told that he has worked out special secret signals with the PowerPoint people here. So if you can pick them, you get extra points on the quiz afterwards.
So thanks very much for inviting me to present to you today. It's my pleasure. I'm a Canadian law professor, and I've been researching investment treaties and investor-state arbitration for quite a long time, and it's personally a great pleasure to see so much interest in the topic. Usually we toil away in obscurity. So pleased with the slides. I have about 60 slides, but I'm only going to use about 6. Okay? So I was asked to speak about alternatives to investment treaty arbitration. I'll call it investment treaty arbitration to distinguish it from other forms of investor-state arbitration. And I've just highlighted 3 broad alternatives. One alternative is courts. It could be domestic courts. It could be an international court. Personally, I have been suggesting fairly strongly that what's needed is an international judicial process to resolve these kinds of disputes rather than an arbitration mechanism. But I'm not going to talk about that today. I'm going to spend more time on the second example because I find this is a topic that doesn't tend to get discussed as much. And this is the alternative of contractually agreed forums. So many contracts relating to foreign investment. Foreign investment, any major project typically has an extensive contract associated with it. So the foreign investor will be party to a contract with a state entity. And that's a form of investor-state contract, and the contract will have its own dispute settlement clause. And the clause may refer disputes under the contract to arbitration. It may refer disputes under the contract to a domestic court. It may refer disputes under the contract to another forum. The important point there is all of the forms of adjudication that are provided for in investment treaties, they can all be provided for in a contract. So the contract can refer any type of dispute under the contract to the same forums, same procedures, could be the same arbitrators. That would be just a matter of how the contract is drafted. So I'm going to talk about that alternative and how investment treaty arbitration interacts with this alternative. Because these alternatives, they're not watertight. They interact, and in many cases, they actually overlap in their role with the role of investment treaty arbitrators. Largely, as I will show, because investment treaty arbitrators have decided that their role should be relatively broad and as a result should overlap with the role of contractually agreed forums, including investor-state arbitration pursuant to specific contracts. The third type of alternative I've just summarized as non-adjudicative alternatives. I'm focusing on forms of adjudication, but I've indicated a few examples there. And I'll just single out risk insurance, which is a whole other debate, but I tend to think risk insurance may offer more for foreign investors in general, especially small and medium-sized companies, especially if it has some level of support from states. But that's another topic, and I won't delve into that. Now, when we can talk about alternatives, of course we have to ask, well, what is the criteria? What is the criteria applied to judging relative alternatives? And sometimes this is framed as, well, find us an alternative that offers as much protection as investment treaty arbitration. Well, if you're asking me is there another alternative that in the absence of investment treaty arbitration offers foreign investors a greater likelihood of obtaining public compensation, the answer is probably no. But that's a somewhat strange criteria to apply in weighing potential dispute settlement alternatives. And I say that because it emphasizes the interest of only one party that's participating in the adjudication. So I suggested some other potential alternatives. For example, how does one or another alternative affect the principle of a level playing field in the marketplace? Non-discrimination principles, relative strengths and weaknesses in terms of a fair and independent adjudicative process. The rule of law, balance, I put those in quotes because they're quite general concepts. I'm focusing here on the issue of a level playing field in the marketplace. So next slide, please. Okay, so first thing, I'll highlight some research that I've done, which to my surprise indicated a very high level of overlap between investment treaty arbitrators' role and contractually agreed forums. So I should add, these numbers are approximate and they're descriptive. I'm not trying to predict the future. These have not been tested for statistical significance. It's just describing the system as it appears in publicly available documents to this point. So I put these little squigglies to emphasize these are approximate numbers, but they're giving you a rough sense. And estimated, something close to 2/3 of the investment treaty cases we could review. That is, we could read the factual description, the descriptions of the factual aspects of the investor's claim in a publicly available investment treaty award in a known case. And it appeared that close to 2/3 of those cases involved a dispute that related to a contract that was very likely to have its own dispute settlement clause. Now that's very, very significant because it means investment treaty arbitration is playing a role that is overlapping or potentially displacing or somehow occupying the same space as contractually agreed arbitration or court litigation, okay? There's some other data on the screen, but I'm not going to talk about that. If we could go to the next slide. This is a little bit more detail on how it arrived at the conclusion. The first stat comes from a review of the descriptions and the arbitrator's reasons and known awards of factual aspects. The next stat, 62%, comes from the areas that the disputes appear to relate to and an assumption that those areas typically include detailed investment contracts that have their own dispute settlement clauses. But anyway, it's just two ways of getting to approximately the same answer, that a significant number, probably a majority, of investment treaty cases are overlapping with a contractually agreed forum. Next slide, please. So the question really is, well, how do investment treaty arbitrators constitute investment treaty arbitration in relation to contractually agreed forums? And I ask this question because many judges, based on a review of many jurisdictions, domestic and international, will say the courts may play a role. The general courts, available generally, may play a role in resolving a dispute under a contract, but only after the parties to the contract have gone first to the contractually agreed forum. We, the courts, will respect that agreement in the contract. And this is actually a primary rationale, a dynamic, that constitutes arbitration in general. Going back to the, say, early 1980s, when the role of arbitration has expanded significantly, commercial arbitration, other forms of arbitration, particularly in the United States, is premised on the courts should respect the choice made by the parties themselves in their contract, where they are going to resolve their disputes related to that contract. And the term used in the literature is party autonomy. Respect for party autonomy. There are other rationales one might imagine. Respect for sanctity of contract is a term sometimes used. Discussions in some courts, I'm particularly drawing on forum non-conveniens doctrine as it originally developed in the common law context, is to minimize risk of conflicting decisions, avoid potentially wasteful litigation. And this second bullet point I've added myself is there's a certain respect for the marketplace's allocation of risk, because contracts come out of a marketplace, at least to a greater degree than investment treaties. Investment treaties are really a political instrument, whereas contracts are primarily a market business instrument. So the last, go back to that slide, this last point was very important. Investment treaty arbitrators overwhelmingly do not take this approach. They do not, I would say, show restraint in the manner of judges in many contexts, in some jurisdictions at least, the ones where there was an elaborate doctrine on it. Instead, they interpret the treaties and apply them in a way that expands the scope of their own role, their own power, to decide disputes in an overlapping way with the contractually agreed dispute settlement forum. And I was so struck by how widespread this is and how overwhelming that I emphasized it in my own book last year. I'm not trying to plug it, okay? Partly why I'm emphasizing it here. This was a really quite a striking thing that came out of a very in-depth review of the arbitrator's reasons, quite a systemic review. Okay, so next slide. Okay, so I'm not going to talk about all the details of it, but I mean, there were of 100 cases where it was possible to review this issue, whether it arose in the award. There were 36 cases where we found that the state had argued there's a contractually agreed forum, the claimant should be expected to go to that forum at least first. If there's a problem with that forum, if the state is interfering with the contractually agreed forum, then there would be a backup role for the treaty arbitrators. But the treaty arbitrators need to first let the contractually agreed forum run its course. Okay? That would be the argument. That was rejected by 30 of the tribunals that argued it was not accepted. And to me, a very good example, perhaps the beginning of this tendency, comes from a case against Argentina called Vivendi. In Vivendi, the originally established tribunal, investment treaty tribunal, did show restraint in this way. The arbitrator said, look, this dispute relates to the contract. Factually, it's very similar to issues that are covered by the contract. We think we, the treaty arbitrators, should wait for the contractually agreed forum to run its course. Then we will see how that forum resolves this dispute, how it interprets the contract, etc., etc. I've already talked about rationales for doing so. But the point is, the original tribunal in Vivendi, #1, did this. And they said, look, come back to us later. If you have a problem with the forum, if you have what's called a denial of justice claim against the state because of interference, sovereign interference with the contractually agreed forum, you come back to us, and then we'll decide under the treaty. This decision was subject to an annulment. Okay, so the claimant, the investor, challenged that original tribunal's decision and sought annulment at ICSID, sought to have it overruled, and it was overruled by 3 other arbitrators, all of whom would have been chosen by the World Bank president because it's an annulment panel, an annulment committee under ICSID. And one of the things I'll get a little bit more detail about, one of the things that's quite interesting is under the ICSID convention, there are limited grounds for annulment. So to annul that original tribunal's decision, they had to conclude there had been a manifest excess of power by the original tribunal. So just reflect on that a little bit. By showing restraint to the contractually agreed forum, the original arbitrators exercised a manifest excess of power and had to be overturned. Now let's get into some of the details of the reasoning for that ICSID annulment committee's decision. There are really 5 elements of it. And I lay all this out in detail in a book. Again, I'm not plugging it. I just want you to know that there's a lot more detail behind it. I'm trying to summarize the point, and I think there are 5 elements to what in the literature actually among the lawyers is called the informal or de facto policy in favor of parallel treaty proceedings. First, a contractual exclusive jurisdiction clause cannot simply say it is exclusive. It must be more specific. It must rule out BIT arbitration specifically. Does that mean it has to refer to BIT arbitration specifically, or does it have to refer to that specific BIT? We don't know. The annulment panel didn't go that far. But there's an interpretive presumption here that an exclusive jurisdiction clause in a contract that was written before the flood of investment treaty claims must not simply say this clause in the contract is exclusive of all disputes under the contract. It must add, and specifically we mean to include any BIT arbitration. So that's the first element of the informal policy. A second element, unlike the original tribunal, the annulment panel said, well, we're not going to focus on factual similarities. Factual similarities between the contractual dispute and the treaty dispute are one thing, but there's more to it. There's a distinctive cause of action here. If the fundamental basis of the claim is the treaty rather than the contract, the treaty proceeding can go ahead. Is it really that difficult as a lawyer to write your claim and emphasize the treaty's broad provisions on fair and equitable treatment and so on, instead of talking too much about the contract? No, it's not difficult at all. So any claimant with competent counsel should have no problem ensuring a parallel treaty claim is possible by the way in which the statement of claim is drafted. This is in particularly assured because of the third component in the policy, which is the tribunal should not look behind the allegations as framed by the claimant. So if the tribunal suspects that factually this dispute is actually much more like the contract than the treaty, it shouldn't ask that question. Simply accept up front everything the claimant says about the nature of the claim. Fourth point, linked to this more broadly, it tends to be a broad approach taken to standards like fair and equitable treatment, expropriation standards, to allow disputes about contracts to be covered by those standards. Okay? I could go into detail about that, but I have a feeling Sean's going to be letting me know I'm running out of time soon, so I'll skip that.
I'm going to exercise restraint for now.
Thank you. Okay, restraint is welcome. So the fifth point was the one I've identified earlier, that it was an excess of authority of the original tribunal not to review all the claims of the claimant in the first instance while waiting for the contractually agreed form. Okay, so next slide, please. Okay, I'm not going to go through this, spend any time with this, but this is just an example of how after the Vivendi annulment, subsequent tribunals en masse picked up this in what I've called an informal policy. They picked up these points. And what did that mean? That meant it was far more likely that they were going to get the work. I'm not saying that's the motivation for what they're doing. It may or may not be. I don't know, of course. But that meant there was a lot more investment treaty arbitration going on, okay? Because of this informal policy to say, we won't show restraint, we won't wait for the contractually agreed form. And these are just examples of quotes from another case. The next slide, please. Okay, there's a few more examples just emphasizing the point that was picked up, so we can skip this slide. I did find one example where this presumption that a clause in a contract that says it's exclusive doesn't mean it exclusives unless that extends specifically to BIT or ICSID arbitration. That presumption runs through all the subsequent cases except for one case where a tribunal said, actually, just because, and here's the quote, this is from Zurich versus Argentina, the addition of the specific ICSID waiver by Argentina, this is to a subsequent contract. Argentina is now aware it's at risk of being, much more aware it's at risk of being sued under the treaties. It adds a specific waiver in a contract, and that specific waiver comes before this tribunal. And this tribunal says, actually, the addition of the specific ICSID waiver has not made a substantive difference to the exclusive forum clause included in the concessions agreements, since the acceptance of the exclusivity of a forum implies, by definition, the renunciation of any other for a forum that should read, or excuse me, fora, whether or not explicitly stated in the clause. That's personally how I would interpret an exclusive jurisdiction clause. But what was notable is this is the only case we found where a tribunal adopted that presumption, and it also worked in favor of the tribunal hearing the claim in this case. Why was that? Because this tribunal added another couple of elements we saw partly in the ICSID, the Vivendi annulment I showed earlier, but it relied on something called the triple identity test. It's a very strict test the arbitrators have developed, which says for the treaty arbitrators to show restraint to the contractually agreed forum, not only must the disputes be factually close to the same, the causes of action must be the same, and the parties must be the same. Meaning, if you're a company, you use a subsidiary to bring the contractual litigation, and you bring the treaty litigation directly yourself, different parties, right? Different companies. Okay? A Zurich's tribunal relies on that triple identity test to take jurisdiction in this case. So moving on. There's just a couple of graphs. The point I'm talking about is represented under parallel claims, which is the sixth jurisdictional issue we coded systematically. The orange is showing the expansive pro-claimant interpretations. The blue is showing respondent or state-friendly interpretations. And this was done across a range of issues, but I don't need to get into any depth about that. So the next one is, those are substantive issues that we coded. Next. Okay, one point about the contractually agreed forum. Well, what about small investors? Small investors have less bargaining power to get favorable contractual clauses than larger investors. I think that's fair to say. It is a reality of the marketplace, but you know, to what extent should we be trying to boost small investors in the marketplace? I mean, that's another debate. But I think it's fair to say that yes, the alternative of relying on contractually agreed forums may be less advantageous to smaller investors because they have less bargaining power to get an attractive dispute settlement clause in a contract. Well, I just wanted to highlight a relevant piece of research, not intended to directly test that point, but I thought it was relevant. And the reason we collected this is we were trying to examine, you know, what's the heart of this system as it may affect governments. Another project, we're doing interviews with government officials in Canada, asking them in general, what's your awareness of the treaties? How do the treaties potentially affect your decisions? How might they lead to regulatory change, good or bad? And the operative example is if there's a non-negligible risk of very substantial liability, say billion-dollar liability, that is going to have an effect in the regulatory decision-making process. It's been confirmed by a number of interviewees. So we focused on, well, what are the big cases then? Because it's the big cases with big money at stake that are most likely to affect governments in their decision-making, for good or ill. And we isolated the 36 awards for more than $10 million as of May 2014, and isolated the size of the companies, the claimants in those cases, and showed how, you know, the great majority of the money awarded. If you actually just follow the money, the treaties are transferring money from public funds to lawyers and arbitrators and to companies, and sometimes individuals. Okay? So we try to say, well, what's the size? Well, companies with over 10 billion in annual revenue took 76% of the money in those cases. Large companies over 1 billion was another 10%. Small, medium companies, which we defined as less than 1 billion in annual revenue, was 5%. And then there were some individuals who got money, and we tried to isolate very wealthy from mere mortals. by the threshold of $100 million in net wealth. And you see the numbers there. So next slide.
And this is probably going to.
This is my last slide, I promise.
You promise, Gus.
I think.
You said 6, and you're on to 14 here.
I skipped a few. Never trust the law professor when he has PowerPoint slides. Okay, so what are some consequences of this? I'll just highlight a few very quickly. You know, some investors have a right to opt out of their contractual commitments, and others don't. Which ones do? The ones who have a legal right to bring an investment treaty claim, and the ones who have a financial capacity and the knowledge to bring an investment treaty claim. Presumably this gives some kind of competitive advantage in the marketplace and in governmental relations. This was highlighted by dissenting arbitrator in Jericho versus Poland. The majority decision, he said, to allow the treaty claim in the face of an exclusive jurisdiction clause, quote, may create a privileged class of foreign parties to commercial contract who may easily transform their contractual disputes with state-owned companies into BIT disputes. Here, only one of the 3 commercial companies which entered into contracts with the state treasury could submit its contractual dispute to this tribunal. Privileged access to public compensation, calculated over $1 billion in known awards in total, where the tribunal had allowed a parallel treaty claim to proceed in the face of a state argument to the contrary. Next slide. I promise, these kind of go together. Last slide. This is it. Other investors may be disadvantaged in their contractual negotiations because if you're more prudent and you hold out for a more favorable dispute settlement clause, you may have to give up opportunities to get the contract in the face of the investor who's able to take more risk because of the presence of the treaty form. Litigation costs have also exploded. This is a conservative estimate of $1.7 billion in legal arbitration fees. That's only in 214 cases, and we're well over 500 now, and that's based on an estimate by the OECD of $8 million per case in legal arbitration fees. Thank you for your patience.
Thanks, Gus. I think we've learned a lot from that. I hereby vow to apply the triple identity test to anything I do in life from here on out. I'm also very glad to hear that in Canada, the definition of a mere mortal starts at $100 million a year, or $100 million in net wealth. Why don't we... we're going to change something from the morning. You're not going to get any coffee here. We're going to go straight into our question and answer session here. We're going to invite Peter Chase up to the podium. Peter is the Vice President of the in Europe of the U.S. Chamber of Commerce. We're also going to invite up Leopoldo Rubinacci, who is Head of Unit at DG Trade on Investment. He's the guy who has to negotiate all these things. You might have some questions for him. And Elizabeth Beer, who is I'm in her way, who is from the Chamber of Labor in Austria and works in EU and international affairs. Guys, we're going to do the same format that we had this morning, really just 2 minutes of kind of your thoughts based on the 45 minutes of presentations that you've just heard here. I will employ my thing, and don't try that Gus trick of having one extra slide in there. I'll hold you to it. Why don't we start with the guy kind of in the hot seat, really? Leopoldo, why don't we start with you? You've got 2 minutes. Any thoughts just to kick off our discussion here? If you just turn it on the bottom, there's a button on the bottom. There you go. You got it. You've got it. You have the power.
Good afternoon, and many thanks to the organizers for inviting me to this event, which I find extremely interesting. I was asked specifically to talk about alternatives to ISDS. So I'm not going to comment specifically on some of the things that were said, but I'm going to try to play the game and do that. But first of all, I would like to make 2 things very clear. When we talk about TTIP, one, as everybody knows, the mandate on investment protection and ISDS is conditional. So there's going to be a final decision about the inclusion of these things on the basis of the EU interest. And 2, we are consulting EU stakeholders, and we're going to take decisions on the basis of an in-depth discussion with the Parliament, the Member States, and the stakeholders. So whatever I'm going to say is not definitive. Now, the context. What is investor-state dispute settlement? it's an enforcement mechanism for standards of investment protection. These standards of investment protection are a set of rules which are included in international agreements. So we're talking about international law, we're not talking about domestic law. The investment protection rules, what are they? I think we can summarize them as being three: non-discrimination, fair and equitable treatment, compensation in case of expropriation. Now, is there something that is fundamentally wrong with those rules? I'm not sure, and I think that as a matter of fact they, to a large extent, form the basis of what is known as the rule of law. Now, when rules are included in international agreements, the question is, what do we do to enforce them? So in other words, what happens when there is a breach of those rules and there is a dispute that arises out of those rules? I think this is very important. What has emerged over time, because it's something that has emerged over time, is that it is important to have enforcement mechanisms. This is what the WTO has, and this is what progressively the bilateral investment treaties have had. Otherwise, one may wonder what is the point of having international rules if these international rules cannot be enforced. Now, in international economic law, the resolution of disputes that arise from a breach of an international commitment, most of the cases, if not always, take place outside domestic courts. Why is that? I think for two fundamental reasons. One, because in many cases, the domestic courts are not competent, because international agreements are not given direct effect. So the national courts are simply not competent to look at a breach of an international commitment. And two, because domestic courts apply domestic law. So what happens if the breach of international commitment comes out of the fact that it is the domestic law itself that breaches these international commitments? The case of the United States and the EU is particularly important in relation to the first point, because both foresee specifically in their free trade agreements that there is no direct effect. So if domestic courts are not able to resolve disputes that arise from a breach of an international commitment, what do we have left? Incidentally, domestic courts, of course, remain always able to resolve disputes arising out of the application of domestic law. And there is nothing in the agreements that the European Union intends to negotiate that says that the recourse to ISDS prevents anyone from recurring to domestic courts. So if we cannot do domestic courts, what is left? The traditional method of resolving disputes in trade disputes is state-to-state dispute settlement. Now, there is a little bit of a difference between an investment relationship and a trade relationship. A trade relationship will rarely involve, contrary to investment, a long-standing commitment of important capital. And it will rarely involve a long-standing relationship between an economic agent and a host state. So, state-to-state dispute settlement would just bring investment disputes back on the front of diplomatic and political relations. So instead of having an investor alone litigating its dispute with a host state, the problem of the investor alone becomes a political problem between two countries. I think it is important to bear that in mind. The second thing is that, and we see that in WTO litigation, if you want to bring a state-to-state dispute settlement, you as an investor have first of all convinced your home state. Now, what is the likelihood of small and medium-sized enterprises or small companies being able to convince, say, the United States of America to bring a case as opposed to large corporations? I think this is a question that is important to debate. So the trouble is that investor-state dispute settlement appears to be, at least for the time being, the method of resolving disputes that is the most adapted to the specificity of an investment relationship. We can have other means of resolving disputes. We can have mediation, we can have conciliation, we can have consultations. And all those are things, for example, that we have included in the agreement with Canada. And all these are extremely important alternative means of dispute resolution before anything else. But the trouble with those means is that they're not mandatory, they're not directly enforceable. So they're very good when they help finding a mutually agreed resolution of a dispute, when the case can be settled, when something can be settled amicably, which is, by the way most of the disputes are resolved. But then, when you really need something that has a definitive nature, then ISDS remains the most effective way. As I said, this is not, this is the thinking that we have for the time being. We've heard many interesting comments, for example, today, and I'm sure we're going to continue hearing some. There is one thing that I want to say in the final panel, what I'm going to say now as well, is that ISDS is definitely not perfect. There is a need to reform the system. There is a need to work on reforming the system, and this is very much what we would like to continue thinking about in the European Commission. Thank you very much.
Thank you. Thank you, Leopoldo. I exercised manifest excess authority there by giving you extra time there. I hope the European Commission will be good to us in the future. We won't have to take this to arbitration. Peter, I'm going to be slightly stricter with you. I'm sorry, but 2 minutes. The floor is yours.
That's fine. Thank you very much, and thank you very much for inviting me. I'm with the U.S. Chamber of Commerce, but I'm coming at this as well based on my own history as a U.S. diplomat, 30 years, and part of which I spent negotiating investment treaties. I was actually, can be very short, in part because Leopoldo touched on the thing that I most wanted to say. A lot of the discussion so far has been about ISDS, investor-state dispute settlement, and not about, in fact, the substantive obligations that it's. What's important is, do you agree with or disagree with the obligations, and then how do you enforce them effectively? But you have to start with, I think, the obligation, and Leopoldo has brought that out. Those three, I would add a fourth obligation, that is the right for an investor to make transfers of capital between the investor and the investment, are pretty critical. I think they're pretty common to all investment treaties. I wanted to ask Mr. John about that, and I would also like to ask Ambassador Karim what your new investment laws, and whether or not, in fact, these four basic principles of non-discrimination, minimum standard of treatment, payment for expropriation and transfers are the basis of your new law. These substantive things, I think, are and should form the basis of international law governing the treatment of a foreign investor who commits capital to your country. They're entered into by two governments willingly that make those promises to each other. This is how I will treat your foreign investor. And as Leopoldo said, they need to be enforced by an international public law forum, which ISDS is a mechanism for that. And ICSID was set up specifically to do it. Leopoldo also mentioned one of the key issues, which is, why do governments want investor-state dispute settlement? And the governments themselves want it to avoid creating diplomatic incidents over investment disputes. And I hope we'll go back to that, because I think that there was a reference to the Obama administration's review of our basic investment treaty, and I fundamentally think that the reason that they retained ISDS was specifically so that they could get out of the business of advocating on behalf of investors.
Okay. Peter, thank you very much. Elizabeth, let me, I'll just hand you this microphone and then I'll turn that one on. Elizabeth, you've got 2 minutes.
Okay. Thank you. First of all, I want to congratulate the organizers for this very interesting conference and bringing so many distinguished experts on one day into Brussels. Well, I'm here on behalf of the workers and the employees of Austria. So we have got the Chamber of Labor. Unfortunately, the Chamber of Labor is not as powerful as the Chamber of Commerce, I suppose. And I want to go a step behind. I don't want to discuss if we want to have an international law on investment, but if we need an international law on investment. And we from the Chamber of Labor, we reject the privatization of jurisdiction because including ISDS into investment agreements, especially with the developed countries, from our point of view, it is a systematic approach to shift political risk from investors to states. And once again, the taxpayer is held liable for the corporate risks and even for the expected profits. So if the system is extended to developed countries, we will locked in for decades as part of the global governance. From the point of view of workers and employees in Austria, we are against ISDS because of, to be brief, because of 3 points. Economically, ISDS is not useless. It's useless because on the one hand, we heard that there is no proof that there is a link between FDIs and international investment agreements. To say it in economic terms, there is no significant correlation between FDIs and international investment agreements. This is one point. On the other point, fair competition in Europe is destroyed. Foreign investors would have better rights comparing with the domestic investors, and most jobs are created in the member states by small and medium-sized companies and by domestic investors. The second point is that ISDS is threatening the democracy. I mean, I just want to think of the situation in Greece. The state have defended specific. Greece had to negotiate haircut measures, and the population of Greece, they had to suffer from the measures of austerity. And now the Greek state is sued by speculators, by financial speculators. So where's the fairness, I ask you? And the third is that ISDS will threaten the economic standards and even labor standards. We were asked the European Commission to carve out, to have a general exclusion clause for the right to regulate. We have a right to regulate clause in the preamble, and I'm not a lawyer, but I was told that it is not binding for the tribunal. So I just want to ask you how you see this point. And we also wanted to have an exclusive clause, an exception for sensitive sectors such as education, as aid, as public and social services, social affairs, regional development, tax policies. But they are, in CETA, they are not excluded from the scope. And so we also come to the critical point that the investment definition is the scope of the provisions are far too big. So I just make a point here, and I think we'll come to that.
Okay. Well, I think that's a good point to stop there. Again, you've got. You've got 3 more thought-provoking interventions on top of 3 thought-provoking presentations. It's now your turn to ask some thought-provoking questions. We'll take them in groups of 3. We'll start, I think it's the 3rd row back, the lady there. Do you want to use that one?
Hello.
Go ahead, and then I'll come to you afterwards. Yeah.
I'll pass you the mic. Poppy Bullock from MLEX. This is a question for Leopoldo. You say that the ISDS mechanism needs to be updated or reformed. That I can't remember the words exactly, but that it's not perfect. But you've been addressing this in CETA, and there's many things that you've updated in ISDS with this, as you've mentioned a few on consultations, and also addressing the issue of companies being able to find, let's say, loopholes in the current mechanism. So could you just give us an idea, are these the things you're talking about when you say that ISDS isn't perfect? Or is there a differentiation between CETA and what you want to achieve in TTIP? Could you maybe give us an outline of how much further can you go?
Okay, that's a good question. You've done CETA. What comes next? Right in front of you? Yep.
My name is Christoph Lechner. I'm from Austria. I'm a member of the ESC Workers Group. I have one question, especially to DG Trade. In the Article 207 of the Treaty of the Functioning of the EU. It says that the EU, in his trade policy, has to take in respect Article 3 of the European Treaty. And in Article 3 you have solidarity, democracy, gender, and so on, development. And now says two lawyers from Germany, Professor Krajewski and Professor Fischer-Lescano, that they miss in the draft for the ISDS in CETA the connection to this EU treaty. Because only to say it's international law and there the EU law does not rule is not possible. That would be excess of authority by the EU, by the Commission, by the Council, by itself. And especially, you see, it's functioning or not?
No, it's functioning. Yeah.
Okay. My special question is, there was a claim against Romania because the state has to change its agricultural quotas when they access to the EU. And the arbitrators have decided that now Romania has to pay 250 million euros to this enterprise because they must change the agricultural quota. What is the answer from the Commission? And the second similar case was Cargill against Poland, also changing agricultural quote, and the arbitrators decided also to pay, I think, 10 million or so euros to the enterprise. What's the solution by the Commission?
Okay, so I think the question there is when does how do you balance the requirements of EU law and international commitments, and some interesting cases brought up there. There was a question in the second row here, if I could take that one quickly.
Hi, I'm Robert Weissman with Public Citizen. This is a question, I think, for Leopoldo. I've been confused about this argument, which I think is directed towards the United States, that U.S. courts don't apply international standards. And if I'm understanding what you're saying, it seems a bit of a circular argument to me, because the standards you're worried about being applied in U.S. courts are the very standards that are being incorporated into the ISDS agreement. That is to say, there's nothing outside of these ISDS agreements you're worried about being applied inside U.S. courts. It's just those terms themselves. And then Peter actually helpful, and the two of you elaborated these three standards, and with a fourth possible, of non-discrimination, non-expropriation, and minimum standards of treatment. And so just looking at the United States, is there a concern that U.S. domestic law does not provide those guarantees for European investors?
Okay, why don't we come back to Leopoldo, since the question seems to be, a number of those seem to have been addressed to you, Leopoldo. Peter, maybe you want to come in, but Xavier also, I think that what's interesting is the idea of how South Africa has kind of dealt with some of these things in its new laws.
No, thank you very much. Now, yeah, it's on. I will speak a bit more slowly now that I don't have the clock. We addressed a communication to the European Parliament and the Council already back in 2010, so well before the idea of TTIP emerged. And we said very clearly that as part of the new EU competence on investment, we wanted to bring about significant improvements on notably the investor-state dispute settlement system. So we said that well before this debate on TTIP started. What we said then, and we still maintain, is that investor-state dispute settlement has shown a certain number of weaknesses. It's not transparent enough. There are issues with the choice and conduct of arbitrators, and there are fundamental issues about consistency of awards and review of awards. And we also said, incidentally, that we wanted to start our investment policy on the basis of the experience of the member states' international agreements, which account for half of the 3,000 plus agreements that exist in the world that Mr. Jean mentioned this morning. And what we've done in CETA is, in our opinion, a gigantic leap forward in changing the system compared to the existing agreements that exist in the world, and not just the member states' agreements. ISDS now is fully transparent, thanks also to our strong negotiating stance in the review of the UNCITRAL rules on arbitration. We have rules on the selection and ethics of arbitrators, and we said that we want to work on an appellate mechanism, and we've laid down the foundations for that in the agreement with Canada. But then, of course, an ISDS system is only as good as it is in reviewing the fundamental substantial provisions that it has to review. And so we've also worked very much in improving, updating, clarifying the standards of investment protection. Now, Canada and the EU have concluded the negotiations. Now it will be the next actors in the system are going to be, on our side, the European Parliament and the Council of European Ministers, who will have to decide whether the agreement can enter into force or not. We have used CETA as an illustration of the sort of provisions that we might put into the TTIP in the public consultation. Why? Because we reckon that the matter being so technical and complex, it was important to show to the average European citizen how, from a legal point of view, these various provisions could be phrased. But we never said that CETA was going to be what we're going to negotiate in the TTIP. In the TTIP, we're going to decide on what the EU approach is going to be on the basis of our discussions with the Parliament, the Council, EU stakeholders. We will take, of course, fully into account the results of the consultation, because we think that this is going to be a very important element that is going to come into the debate. So we don't exclude at all that the approach in the TTIP may be different from what we have done so far in CETA. And then we also don't exclude at all that through the process of the public consultation, we may actually learn a few lessons. And then we will have to decide what do we do with these lessons for the future of the EU investment policies. Shall I continue with the other questions?
Yeah, I mean, this question of local kind of obligations.
Yes. I maintain what I said, and maybe I can simplify that you can go to EU and US courts on the basis of EU and US domestic legislation. But from the moment you decide to have an international set of rules, then these courts are no longer able to review those commitments. So ISDS comes into that play at that level. So if you have international investment rules, do you want, yes or no, that they are enforced? If yes, ISDS then becomes the means to enforce those rules. Now, what happens? Why have we discussed the inclusion of investment protection rules in TTIP? I think for several reasons, but I'll just mention a couple. The first one is that today, the relationship, the economic relationship between the EU and the US is extremely complex. It covers everything. And becomes very difficult to distinguish artificially between the constituting elements of this economic relationship. Trading goods, trading services, investment is all part of the same bundle of the economic relationship. Nowadays, most of the trade takes place through investment, and certainly most of the trade in services takes place through investment. So the fundamental reason why the EU legislator has decided to give us the competence on investment protection was precisely that we could bring together the elements of market access on investment and the elements of investment protection. Before the Lisbon Treaty, we had the EU negotiating more or less harmonious rules on the access to markets, and then the member states deciding for themselves through a number of different agreements what rules applied once you had made an investment. And at the European Union, we want to bring all that together. So this is the fundamental logic, if you want, in policy terms, of why we have come to the conclusion that, more or less as a default, we think that investment protection rules go together in free trade agreements. Now, the last thing to come to your fundamental question on national treatment. What I know is that in the European Union, when you establish yourself, for example, as a company, you're considered as a European citizen. So you can conduct trade and you can invest cross-border within the European Union on a pure national treatment basis. This is not necessarily the case in the United States. In the United States, you don't have the same level of national treatment from a legislative point of view as you have in the European Union, because it is always possible for the legislator to go back to the original owner in deciding how companies would be treated. So this is a fundamental difference. It is also one of the reasons why the European Union has always considered that national treatment is a fundamental element in international trade agreements, because we treat foreigners like European citizens, but this is not the case in most of the countries in the world.
Xavier, I'd like to come to you just to come in on some of these points that have been made here, because really how you're dealing with these kinds of questions in your new law, the new investment law, and also in the SEDEC model bit, I think is a really interesting question.
Well, thanks very much. I'll start where Leopoldo ended, saying that in South Africa, foreign companies are treated as South African companies. And there's no distinction at a state level or at a provincial level. You have the same level of access. So that issue doesn't arise in respect of our relationship. There were other questions, I think, on the sort of 4 sets of obligations that I think Peter raised. Non-discrimination, it is in the Act. There's a clear articulation of national treatment for the first time. We talked of non-discrimination in our Constitution. Now in the new Act it will also spell out what we mean by national treatment. It's non-discriminatory because it applies to everyone. So any foreign investor from any country would be subject to the same set of rules. We don't have a fair and equitable treatment in the way that it's articulated in bilateral investment treaties, for the reasons that have been raised already, the serious problems that arise in fair and equitable treatment in its application. But you have access to courts. You have equal access to courts. Foreigners and domestic investors have access to those courts. And that seems to be the more important access to administrative justice in South Africa. Compensation provisions are set out in the Constitution. They're carried over into the new Act, and provisions related to transfer are carried over. So all of those obligations that you would find in international treaties are expressed clearly in the new Act. I mean, what occurred to me in that question when we talk about non-discrimination. I mean, there's another way of looking at it. I mean, there is a discrimination now between, if you have ISDS, there's the discrimination between the domestic investors and the foreign investors there, that the foreign investors are treated better. So the question is, now you're introducing, in a different way, you're introducing discriminatory treatment. There's also discrimination between between investors from countries where you've signed the investment treaty with and those that you haven't. So, for every other country, we don't have an investment treaty. They don't have the same treatment as, say, countries that. So the question of non-discrimination is, I mean, we have to look at it, I think, a number of different angles. So the Act, essentially what the Act is trying to do is to look at those provisions that you ordinarily find in investment treaties and transpose and locate it in national law, but bring it in line with our Constitution and legal framework. The model bit, I think, we had started on that. It was in the decision by the cabinet that we have to develop that model bit, and so the way we approach it, as I said, is at a regional level in terms of SADC. But I think there's a very high standard that we've set for ourselves to negotiate bits in future. There has to be an economic benefit. And again, in the discussions, I'm not hearing from anyone saying aside from that we're doing it because we've always done it, but where is the economic benefit that arises out of it? And I still haven't heard an answer to that.
I think the answer is that there's that open question of whether or not ISDS encourages FDI or not, which depends on the studies that you look at and the methodology, as we heard earlier. I mean, I think this question of non-discrimination is really interesting. We'll come back to the floor in a second. This question of non-discrimination is really interesting to me, in part, as someone who has spent his life moving around between legal jurisdictions, not because I'm evading anything, but very simply because that's the way life has taken me. But the point that the argument is that this is preferential treatment for foreign investors is interesting, because from a foreign investor's perspective, often the argument is this is to balance what is inherent discrimination in the local legal system against us. You know, and it depends how you view this, the kind of ISDS as an instrument. Let's go back to the floor. We got 3 more questions. You've already had your question. So we'll go next to you, then we'll go into the third row. The answer, do you want to, Leopoldo, do you want to, is there a... No, the question was very much to Leopoldo in terms of Article 207, was it, of the EU treaty and its relationship to Article 3 and so on. That was to Leopoldo, and I think he answered it.
Yeah, no, I'm very happy to answer the question. Of course, Article 207 of the treaty applies to the EU activity in negotiating international agreements. It doesn't apply to the activity of individual member states negotiating bilateral investment treaties. Now, since the entry into force of the Lisbon Treaty, due to the new exclusive competence, there has been a question as to what is the possibility of individual member states negotiating their own bilateral investment treaties. And there is legislation in Europe, it's a regulation of the Council and the European Parliament, that foresees that the Commission can authorize member states to negotiate their own bilateral investment treaties if a certain number of conditions are met. And of course, the first of those conditions is that the bilateral investment treaty of the member states has to remain within the boundaries of the obligations that the member states have undertaken within the European Union. So the member states have the obligation to ensure that all their bilateral investment treaties do not put themselves into a situation of conflict with their own European Union obligations. And that is something that the member states need to continue looking at. So we don't see that there is any, if you want, contradiction between the fact that you have to respect as a member state a certain number of obligations under EU law and the fact that you entertain international relations with third countries within bilateral investment treaties. Now, in relation to the relationship between Article 207 and Article 3, I know that there is a lot of tweets and elements in the blogosphere saying that investor-state dispute settlement is anti-democratic. Of course, we have difficulties in understanding this concept. If I take the member states' bilateral investment treaties, they've all been ratified by national parliaments. And whenever we're going to conclude EU agreements, these EU agreements are going to be concluded by the European Parliament, which is elected directly by the European citizens, and by democratically elected governments represented in the Council. So I don't think that we can say that there is a conflict with democracy, between democracy and investment protection rules. Thank you.
Let's go back quickly to the floor. There was one in the third row there. I'm going to have an inherent bias against people who have been panelists, so fair warning, Paul. There.
Thank you. I'd like to come back to Pascal Canet from the European Services Forum. I'd like to come back to the argument that an investment protection agreement is not attracting FDI. That's too easy. That's too short. Shall we say that we don't need an FTA, any FTA either? Because if you ask for a company, are you going to go and do some trade because there is an FTA? The answer is no. It's not that easy. The question I have to put is to a business, to a CEO of a company is, what are the kind of arguments and criteria that you're using when you decide to invest in a country? And they're going to go through a long list of criteria. The market, the size of the market, the competition, the skills, the tax incentive, all of these things are going to go first. But always, at any case, you will have, at a point in time, risk country assessment. And in that risk country assessment, the company is going to look at whether this country has signed an FTA, whether this country has signed a BIT, whether this country has signed all of these things. That is legal security. It's part of the legal security.
Okay, so there's a holistic treatment of the investment.
So it is not true that it is not attracting FDI, but it is part of it.
Okay, so it's part of a bigger picture question mark. We got a back in the left. I think you're 1, 2, 3 rows back. You see her with her hand up. There you go.
Thank you. My name is Pia Eberhardt. I work for Corporate Europe Observatory. I have one short comment and 2 short questions. The short comment is that it's a real pity that Jan Klein-Heisterkamp is no longer in the room, because I think he has written a very interesting article rebutting the argument of the Commission and the American Chamber of Commerce, saying that the investor rights will be enforceable in domestic courts if you have the necessary implementing legislation. The questions are to Gus van Harten, because I think we have now heard from the Commission that ISDS is really just a process, and what's important is the investor rights. But I know that you have worked a lot about the flaws in the process, so I wanted to hear your view on, don't worry, ISDS is just a process. And the second question is, if you see any flaws in the process, do you think that they have been fixed by the Commission, as we have also heard? Thank you.
Okay, and just over here on this side there.
Thank you. This is Marianne Fernandez from European Digital Rights. I had a question regarding the coherence in EU trade policy. So actually, now we have the mandate of TTIP public. Well, it was leaked 1 year ago. And now I wonder, with other trade agreements like CETA, that we still don't have the mandate, but still we have the text. So I wonder whether also regarding ISDS, the mandate on ISDS was actually conditional, or what's the Commission doing exactly to have the mandate public? Thank you. On
CETA, do you mean?
Yes.
Okay. All right, 3 quick questions there, and I think we're going to have to cut it off there because we're running out of time. Peter, why don't we come to you? The holistic case for investment. I threw a question mark on the end of that there. I mean, there is this argument, and it's coming up. Celeste is right up there on the screen behind you, saying ISDS attracts investment is a myth. But there is this argument from business that it's part of a bigger case or a bigger portfolio of things that you need to have in place. So, do you want to just respond to that?
Sure. Thank you very much. Investors will make investments, as was raised by Mr. Kernis. When they make their investments, they look at all of the things associated with that, including, of course, the legal framework in which they're going to be investing. When they invest, if they have a lot of confidence in that legal framework, then that will make it easier for them to invest. The greater the level of risk that they perceive, the higher the return that they will require on their investment. And I know this from the time when we were doing a review of U.S. investment policy in the 1990s, and in fact I spoke to a lot of companies at that time, and this was an issue for them. It's not the determinative issue, because of course Ireland has no investment treaties and Ireland has a lot of foreign investment. But it is a factor, and the more questions they have about the domestic investment environment, the more important that factor will be. I'd like to turn very quickly to the issue that you wanted to focus on, which is this question of discrimination and how you do it. Just as I mentioned before, because governments are aware that investment helps them grow, and I think this is something that, again, Mr. John could have spoken to a little bit on his panel, and because they're aware that this question of legal and political risk is a factor in capital coming in, they do enter into these agreements, which say, as has been mentioned, 4 pretty basic promises. I'm not going to discriminate against you because of your nationality. But that means, of course, you're subject to all of my national laws otherwise. Then you go on to the minimum standard of treatment and expropriation and payment for that. Those basic promises, they feel, with a good system of domestic law, will help attract investors. Now, one of the things that's often missing in the discussion here, of course, is that when two governments enter into these treaties, providing these promises, it's done so on a reciprocal basis. So, for instance, some people have argued about whether or not developed countries need, quote unquote, investment treaties. Well, development countries, Germany's 134 treaties, include, at a minimum, one developed country, Germany. And Germany undertakes these obligations quite willingly because Germany does not think that it will violate them. It feels that it shouldn't. And I think that that's an important thing, and it's the reason that the US government also feels that we can enter into these obligations. And I think that one of the things that's interesting about TTIP is that for the United States and Europe, European member states, many of whom have enshrined these sorts of basic promises on the treatment of foreign investors, we should be able to enter into an agreement like this, and we should be able to take whatever dispute settlement mechanism is needed to ensure that they're effectively enforced. We believe that our government should be held accountable. We can go further than that, but I think that the reason that there's a discrimination element that people perceive is that the governments are saying, I am making this promise for your investors in the context of the treaty. And so it needs to have its own dispute settlement mechanism.
Gus, do you want to weigh in? You've been awfully quiet and you had 45 slides left by my count.
Yes, I'd love to weigh in. In technical terms, the fundamental problem with investment treaty arbitration is the absence of institutional safeguards of judicial independence in the final resolution of public law. What I mean by that is investment treaty arbitration is a radical departure from how disputes about the boundaries of sovereign authority and the corresponding allocation of public money, how those disputes are ultimately resolved. For example, how is it that a parliament can be overridden on constitutional grounds in a court? That's the usual way in which those kinds of disputes are resolved. Why in a court? One important reason is because courts are institutionally independent in a way that no other decision maker is. Why are they institutionally independent? Because of certain characteristics of judicial institutional independence. Secure tenure, an objective method of case assignment. Cases are not assigned by an executive official or any other discretionary official. There's an objective method such as rotation or lottery. There are prohibitions on the judge working on the side as a lawyer because of concerns about issue conflict. The judge will interpret the law in a particular way to favor paying clients on the side. We outright prohibit judges, at least in the common law context, I'm sure in many civil law contexts, from working on the side of the judges because of that concern. There are a whole series of these well-known institutional safeguards. They're all missing in investment treaty arbitration. The result of that is the adjudicator may be reasonably perceived. Whether there's actual bias is not our concern. Doesn't have to be our concern. The concern is a process that has integrity because it is fair and independent as core components of the rule of law. The problem is when the institutional safeguards are removed in the context of asymmetrical public law claims, the adjudicator has economic dependencies that a judge would not. There's an economic dependency on prospective claimants. Here, that's foreign investors, typically deep-pocketed large companies. Because if the arbitrator is a repeat player and wants future work, it can be reasonably perceived the arbitrator will be concerned about prospective claimants believing, and their lawyers believing, they have a reasonable prospect of success. Likewise, there's a dependency on those who exercise discretionary power
to appoint arbitrators when the parties do not agree. Where does that discretionary power reside? It gets complicated, but the essence is it resides with executive officials. That makes this process political in a way that courts are not political, because every executive official owes his or her position to certain political atmosphere, certain political pressures. This comes to the next part of the question from Pia, which is, what about the reform initiative of the, thank you for reminding me, Sean, of the European Commission, in the as represented by the CETA, for example. About 2 or 3 years ago, I've never said this publicly, but about 2 or 3 years ago, so now please pay attention. I sent a short paper to a member of the European Commission who was closely involved in the CETA negotiations, so I happen to know. And in that paper, I outlined, it was short, but it was detailed, how an arbitration mechanism in Canada, in an internal trade agreement called the Agreement on Internal Trade, which was motivated in part by NAFTA and by NAFTA's investment chapter, adopted various reforms to the equivalent to investor-state arbitration in that internal trade agreement. Many of those reforms replicated institutional safeguards of judicial independence within the arbitration process. It was not a judicial process, it was not perfect, but it was a significant step forward. For example, it was a roster, objective method of case assignment, filtering process by a trade official in the claimant's home province, a cap on monetary awards. These things were laid out. And I emphasize that only because the European Commission was made aware of these options. They are not represented in the CETA. The closest that we get to this is a roster. I won't go into the details, but it is a very limited roster. It's not mandatory. There's still executive discretion over who's appointed. There's no objective method of case assignment. There's also a plan for a code of conduct, but we won't actually see a code of conduct until you look at the EU-Singapore Free Trade Agreement. And the problem with these codes of conduct is, you know, it's a code of conduct. It's guidelines. It relies on self-reporting, self-regulation, disclosure of one's own connections. It's very difficult for anyone outside to verify whether an arbitrator is complying with the code of conduct. That's why we have the institutional safeguards in courts. Linked to this, I wanted to stress a point that's been brought up about the substantive standards. With all due respect, these substantive standards, in my judgment, go well beyond basic obligations. In each of the standards you refer to, there's a catch. And the catch in the arbitrator's decisions becomes the rule. And that's the problem. The catch with fair and equitable treatment is this gets extended beyond basic concepts of, you know, control against bad faith, obvious arbitrary behavior, to broad limits on the ability to change a regulatory framework without compensating on a market valuation basis and so on. With expropriation, it's indirect expropriation. The notion of indirect expropriation has vexed legal systems going back for 200 years and has been a subject of great political debate and is resolved in legal systems in a variety of different ways. The point is it gives tremendous power, in this instance, to arbitrators rather than judges to make calls about those essential legal concepts in any public law system. The third example is non-discrimination. Here we get into the issue of not de jure, intended discrimination, but effective or de facto discrimination. There are cases of de facto discrimination that certainly warrant compensation, but here we also enter into the realm of wide discretion on the part of the arbitrators to say, how easy will it be to establish de facto discrimination, thus entitling the claimant to a full market compensation award. Retrospect to the original act, and the fourth example, capital transfers. My colleague Kevin Gallagher, an economist in the United States, has done wonderful work showing the difficulties with the US model because it does not incorporate exceptions to allow for capital controls in the context of a financial crisis that can be very valuable from a public policy point of view. But I would apply that to the US model, not to the European Commission's model on that point. Lastly, one point to stress. In my judgment, the European Commission's model, which I have looked at closely, is very close to the US model. There's very little variation from the US model. So these radical change, if that's the impression that one has, I can see the change from some member states' BITs. But if we compare to the US model, the European Commission in these agreements is effectively adopting the US model. There are a few exceptions, some positive, some negative, but I just wanted to stress that point. I think it's very important.
Okay. We're going to have to wrap this up quickly, but Leopoldo, I've got to put you back in the hot seat again because there were a couple of questions that we've left unanswered there. One was, I mean, Gus has raised this again, the kind of the question of the flaws in the fix and the patch there, which we had in the question there. And second, a very simple question: are you going to release the mandate on CETA now that you've released the final text?
No, thank you very much. The mandate, I don't like mandates very much. I keep on telling my member states that it's a set of negotiating directives. It's an annex to a council decision which indicates what are the objectives that the Commission should pursue during the negotiation. Now, once the negotiation is over, the mandate is, and not so interesting anymore. So in relation to CETA, what is really important is that we have released the text as it results from the negotiations. That is what the debate should be about. Now, still on CETA, I think, Gus, you have a certain number of extremely important points. The question of the review of arbitral awards. First of all, I know a little bit the irony in the system, because you may know that the work that has been done internationally on awards, in arbitral awards, is precisely to make sure that once there is an award, this award is going to be enforceable. And the ICSID system foresees that awards can be enforced basically anywhere in the world. And that was precisely to try to make sure that once there is a decision by an arbitral tribunal, this decision not only is final, but is also enforceable. Otherwise, again, the system would not be strong enough. But now, on the basis of the experience, there is now this concept of, hang on a minute, whereas in any domestic jurisdiction you have at least one level of appeal, because judges actually can make mistakes. In the arbitral system, you don't have anything. I think that this is one of the fundamental points that we want to insist on, is that we don't think this is right. We don't think that it is right that an arbitral tribunal meets, decides, and that's the end of the story. There must be a system of review, and this is what we want to do. We have laid down the foundations in CETA, and certainly the intention we had when we started thinking about TTIP was that in TTIP we should work towards this question of this famous appellate mechanism. Then, yes, we can discuss at length as to whether what we've done in CETA is good enough, is not good enough, and so on, but at least we've tried. I still think that we have a certain number of differences compared to the US model. One thing that I think is important is that we should not dismiss too easily the changes that we've brought in terms of rosters, in terms of code of conduct for arbitrators, in terms of costs. In CETA, it is the loser party that bears all the costs. And in terms of dismissal of frivolous claims or claims which are unfounded as a matter of law, we think this is very important. Final point, if I may, on the question of discrimination. I think it is the inherent issue with bilateral economic agreements is that they create rights and obligations only for the parties which they, to the two contracting parties. It is a fundamental discussion in trade agreements whether it is okay to do free trade agreements as opposed to try to have a multilateral system of trade liberalization, because trade agreements always result in some deviation of trade. So the whole question of investors being treated in a different way depending as to whether there is an international agreement in place or not would in theory be best addressed by a multilateral effort, but we have to accept that we live in a real world, and for the time being at least there is no appetite for any multilateral efforts. The question of discrimination of domestic versus foreign investors, I think we have to put that in two elements of context. The first one is, where are we coming from? We're coming from that in international law, absent international investment agreements, there is nothing. A state does not have any international obligations concerning the treatment that it must afford to foreigners on its territory. So investment agreements come there to correct this imbalance. The second point of context that I think is important is that the comparator is not the foreign investor and the domestic investor. The comparator is the type of rights and obligations that the two contracting parties to an agreement undertake. And in investment protection and ISDS, the obligations are reciprocal. So I consent to arbitration by foreigners against me on condition that you accept that you consent on arbitration by foreigners against you. So the consent that the European Union gives to Canada as part of CETA is only there because Canada gives the same consent to European Union economic operators to go to arbitration. Thank you.
Leopoldo, thank you very much. And thank you again all for a fascinating discussion. Thank you again on the floor for some fascinating questions. If you can put your hands together and then... You've got 10 minutes to get caffeinated, and then you can come back here for our final panel.